Today we're going to talk about judges. Judges are the people who are responsible for controlling the courtroom and answering questions of law in a trial. More on that in just a moment. People who become judges are really just lawyers who get promoted. They don't have any special training or talent other than the fact that they are selected to do this job. In fact, I know a judge who frequently says, "I didn't have to take a test to get this job." The fact of the matter is he did have to take a test. It was called a bar exam, but he didn't have to take a test after that to get the job of judge. Now, judge is a very difficult job to have and do because you are being asked to decide issues for people and you have to do it right. And you know that if you don't do it right, there is an appellate court that sits above you who will fix the mistakes that you make. Judges do make mistakes. They make them frequently. In fact, every time an appellate opinion says reversed or remanded, you can pretty much count on the fact that somewhere along the line the judge slipped up. Now that doesn't mean the judge is a bad judge necessarily. It just means that he either exercises discretion in an inappropriate way or that he answered the question of law incorrectly. Appellate courts exist to correct the errors that trial judges make. So what kind of errors do trial judges make? One of the most common is they admit evidence that should not be admitted, or they exclude evidence that should be admitted. Most of the time, this is entrusted to their discretion. The reason that's important is because the judge has, in most instances, the best view of the particulars of the case. He is the person who sees the clients, he's the person who sees the issues in the case, and he understands how those issues interact. An appellate court is only going to get the case for what amounts to a few minutes of oral argument. It's not going to have it for possibly as long as 18 to 24 months before it ever goes to trial. So when a judge makes a decision in a case, it's usually based on the fact that he's been with that case for a suitably long enough period of time to understand the issues. But even in that situation, where he understands the issues and knows what's going on, it's still possible for him to exercise discretion in an inappropriate way, or in a way that prejudices one party over another. And when that happens, an appellate court will step in and answer the question, hopefully correctly, for the appellant and the appellee. So that's one way that judges can make mistakes. The other way, of course, is for them to get the question of law wrong. Many times the nuance in a case is what determines how the question of law should be answered. All you need to do is look at one or two Supreme Court opinions and you will see that quite frequently it is what seems to be the most insignificant of facts that drives the appellate court decision. And that's because the law can be a very funny thing when it comes to answering questions about how facts should be presented to a jury. Now, it's important to remember that the judge is only the judge of the law, and he makes legal decisions that affect how the law is presented to the jury. He does not make factual findings unless he is asked to, or unless it is a case that is entrusted only to judges. In many states, contract issues are simply issues of law, and as a result, a contract issue is decided by a judge. Divorces are usually decided by a judge because they involve purely legal issues, although in many cases there are facts that need to be found and that sort of thing. But the bottom line is that the judges get to make those decisions because it's not necessary to burden the jury with that kind of fact finding. So where do juries make decisions? They make decisions in cases of personal injury and tort law, where someone has been injured. That's because juries get to determine, for example, the issue of damages. When someone has a spinal cord injury and is no longer able to walk, the value of that injury to them is something that's properly entrusted to a jury. Now, the legislatures in several states have seen fit to take that away, at least in part, from juries. In Texas and even in Missouri, where someone who is injured in medical malpractice and gets their recovery is limited in certain instances for pain and suffering to a preset amount. Most lawyers who litigate those cases don't feel that's fair, but of course most defendants who probably didn't intend to screw up in the first place certainly do think it's fair. But of course the people who think it's most fair of all are the insurance companies that often help help their elected representatives get reelected. And that's why so much of the law in this regard, where you have caps on economic damages and non-economic damages, is driven by insurance industry concerns. By the way, insurance industry, one of the most profitable in the country. Revenue in the billions of dollars. And yet, when you go to make a claim, they're the first ones to nickel and dime you to death. But of course, that's why they have billions in revenue too. So judges are entrusted with making the legal determinations, and juries are to determine the facts. So, for example, whether the doctor deviated from the standard of care, that's a fact question that the jury decides. Whether the opinion of a cardiologist can be admitted against an anesthesiologist is, in most cases, a legal question that will be decided by the judge. This is the difference between judges and juries in civil trials. In criminal trials, the only difference is that the issues that are being decided are criminal issues. Did the defendant rob the store? Did he carry a gun? That sort of thing. And in many cases, particularly in a close case, a defendant may wish to have the case tried to a judge as opposed to a jury if the facts are sufficiently awful. And the reason is because a lot of times people use emotion to decide cases instead of reason. And in that situation, it's better to have a judge who tends to be more rationally based in his thinking than having 12 people who are easily inflamed by pictures of bad things that have happened to otherwise good people. So that's the story of how judges and juries work together and how judges operate. Judges have a difficult job. Nothing in this video should be intended or should be taken as my criticism of any particular judge. They have a difficult job and most of them do it very well. There are a few outliers. Judge Judy, who I think makes way too much sport of litigants, is not a very good role model as a judge. I'm sure she's a fine human being, but I don't think she does a very good job as a judge. I think Judge Cahill in the Chauvin case was a very fair judge, very good judge. He simply made some errors. I think there are a lot of judges who don't get nearly enough credit for the hard work that they do in understanding cases. And as a result, that's why I think most of the time judges get the benefit of the doubt from the appellate courts, because they're the ones who are sitting in the hot seat, making the determinations as they go, and they don't get usually a chance to second guess themselves. If they did, they'd be like the umpire who would all the time be called upon to second guess his call. Judges are umpires, and they decide questions of law, and they don't care about how you feel about their decision, and they shouldn't, because they're empowered to decide the law. I hope you found this interesting or helpful, and that it's something that will be of value to you. If you would, I would love for you to hit the subscribe icon over there and subscribe to my channel if you haven't already done that, and smash that like button. You smash that like button, makes you feel good all over. You feel good all over for the whole day, in fact, if you smash that like button. So please, smash the like button for me if you would. It makes it easier for YouTube to understand that this content is valuable and helps people. Thank you for watching. Have a terrific day.